Greetings, everybody. Just starting up the live. I'm gonna get started shortly. Today we're going to cover more interesting material. Benji Comics. See, I became a signatory, but still no login. Message me. Send me a message on TikTok. Did you? Yeah, we talk about it on TikTok. Then we can get you set up. You need to download Telegram. That is a requirement if you want to partake in the group chat and the updated information. All right. Let's see here. Yeah, today we're gonna talk about an interesting topic. Yeah, we're gonna get started in just a minute. Welcome one and all. Welcome. If I could have an early question. Dennis?
Wagwan, my general.
Dennis, big up yourself. Wagwan.
Wagwan, my G. Everything good?
Yeah, man. Me there 1-2 same way, you know?
Happy New Year, man.
Yeah, man.
I
Great
don't
New
know
Year.
happy as it should be, but we are give thanks, and true.
Yeah.
Real, man. We just glad to see you again, and we have to hear you. You see? You don't know everything go.
Powerful. Always.
We are a freedom fighter, you know, so we have to encourage each other, you see?
Yeah, man. Long time.
Real, man. They are just
Everything
getting
good?
to work, you see the start, get one house, have a paint. I think kind of sticky in a place, but then God still a provide, you know?
That
Me
is
take
it.
a 5 and see you there, so me say, let me hear you up. I go and like
Yeah, man. Manners and respect same way.
It's my G, man.
Yeah, man. Thanks for stopping in and sending on the hail and them thing there, you know?
Yeah, man. Respect, man.
Yeah, man. Big up. We're about to get started.
Just keep up the work, man, because me have my side and me I deal with same way, you know. We might not educated as you on the last side, but me educated on the right side. So, you have to defend me rights. And then, November 20, police them come take me out of my house, you know. And me take my phone and video, then take my phone and delete my video and link me, you know. And me promise them, say they can't get away with that, so. We are fighting a different way, but for one cause, same way, you see.
Yeah, man, you have to stand up for something, you know.
Yes, man. Me already carry my statement go in the come. And we tell them, say, this is not no investigation. This must, we carry this as a report for them to be arrested. And you know, see them in the move yet. So, as soon as me get the code sitting in my pocket, when me can go up there, station, me go demonstrate for and demand them to be arrested. And that's when me go take it. You understand? So, you have to rate man like you in the system and I try do what you can do for educate us here and keep us fighting.
Yeah, have to.
Mm-hmm.
Yeah, so we're about to get started still, you know, so yeah, man.
Yeah, man, respect, man, because I pass through. Here's us a one love here.
Yeah, man, big up same way.
All right, my G.
All right, cool. All right, peeps. We are about to get started. So let me free up the screen. Sabak, lawful, always. Welcome, welcome, one and all. Lawful, always. Welcome, everybody. Kem, lawful, always. As you drop in, you can leave a welcome message in the chat. Thanks for joining. Today we are going to talk about the court system. We're going to talk about the processes and procedures that are supposed to be happening. Right? Whole heap of time we go through a process that they claim is the legal process by which the court is put in motion. But when we look at what is actually being done, that is far from the truth. Far from the truth. Excuse me. And if we don't confront these things, and the state or the courts do not find a problem with it, then it is just going to continue. All of these things that people are complaining about, they are just going to continue and continue, because unless we have a way of reaching the court and expressing our frustration or disapproval with what is happening, then who is going to change it? Obviously, those that are in power, like in parliament or the houses, the House of Parliament, they are the ones putting many of these procedures in place. As far as the court rules are concerned, the courts are typically the ones who draft their own legislation or their own rules for the courts. So if the drafters of the Constitution, the drafters of the Acts of Parliament and the rules of court find no problem with the rules that they are putting in place, then obviously they are not going to make any changes that benefit those who are outside of that circle. So today I am going to get deeper into this practice of asking people guilty or not guilty, right? And I am going to share quite a bit more information as it regards to these tickets, right? We already shared quite a bit of information, but we're going to share quite a bit more regarding these tickets, regarding the court appearance, regarding allegedly standing trial for allegations made by a constable. In many cases, sometimes it's not even a constable. Sometimes it is something completely different, right? So first things first, right? What is a ticket? What is a traffic ticket? Now, a traffic ticket, as you may or may not know, is currently considered a transformative document. What does that mean? It means it is a document that is considered to work depending on your performance, depending on whether or not you pay the ticket, depending on whether or not you contest the ticket, depending on whether or not you show up to court. It depends on your performance after the ticket is issued. And if you've been on my page for a while, you would have seen the pinned post where I go over these tickets and show you exactly what one can look for. And again, this information is not legal advice. I am not an attorney. I am not a lawyer. And I do not provide consultation. So no, you can't call me and you can't tell me about your situation and ask what you should do. I can only provide my opinion on what I would do if I was in a specific situation, right? But when we talk about tickets, the general public have no idea what these instruments are, right? So we're going to get started on that shortly. So give me 1 second. Let me take care of something. Okay, so yeah, I had to go mute for a second. So what we're gonna do is we're gonna start from the beginning. We're gonna take a look at a traffic ticket and we're gonna go over a few things as it relates to the law, right? So let me find back a ticket so we can go over it. Let me see if I have one in my little archive over here. So let's see, ticket. You know, I'll share a little interesting story while I look up this ticket. You know, when I time yard memes, I don't know if I'll be able to reach it while I'm in the live. So I'm gonna pull up one of mine and I'm going to edit out the portions that are too revealing. But anyways, I remember I was traveling along Trelawney side at one point, and I got a ticket. What the fuck, I got 3. And the constable stated that I did an unsafe lane change. Right? So I say, do you have evidence of that? And the constable say, sir, we saw you change lane and you change lane on a restricted part of the road. You're not supposed to change lane at that section of the road. So I say, what law is that? Him say, sir, I'm not going to argue with you, you know. I said, no problem. I was just asking a few questions before you issue the ticket. So him say, documents, please, blah, blah, blah. We go through the whole, like a foolishness, right? No, I said to him, you know, say, when this goes to court, you're going to have to bring your evidence, right? Okay. So instead of him writing the ticket, him call one of him colleague and tell him colleague, say, yo, deal with that. And he proceeded to go randomly stop another car. So when I went ahead now and I looked up the ticket after about 3 weeks. As a matter of fact, as early as last month, I looked up the ticket. And there is no record of the ticket, right? Apparently, he figured out that he probably don't even bother want to deal with that. Because, you know what, they want something easy. They don't want something where they are going to have to go to court. They're going to have to do all of these extra things. They want something where they write the ticket and you just go pay it, right? So I was actually getting so ready to go into the courts and go through what people complain about being this process. And I was not afforded that opportunity at all. The tickets are not in the system. And once the tickets are not in the system, how are you going to contest it? How are you going to show up in court, right? So anyways, I am still going to give it some time and see and see if it shows up at some point, right? Sometimes they claim the system is not working properly. The system is not working right. So it may show up or it may not show up. Now, I thought these tickets were electronic, so how comes you can write the ticket and it don't show up? You want to tell me the systems are independent of each other? Anyways, you know, say I don't see the ticket. Let me pull one from this other archive here. You know what? Let's forget about the ticket. We already know what a ticket looks like, so we don't really have to go through it. See? You get a ticket and the court is going to claim that you have an opportunity to answer to the ticket, and based on that opportunity, you were granted due process, right? Based on the opportunity to respond or challenge the ticket or make the payment or whatever, you have the opportunity to perform. You were apparently afforded due process. So, a couple of things here. Couple of things. And we went over a couple of them before, but we have to speak in context here. So we're going to pull up the Constabulary Force Act. Because this is our first line of defense, the Constabulary Force Act. This is what's called a public law or a public statute, and you should be using it to your advantage at all times. When you're ready? Stay ready. Justin, lawful, always. So, I'm going to do the explanation first. And then we're going to go through this entire thing on the lawful side, on the statutory side, showing where in law we come up with all of these options, right? First things first. Is a constable authorized to serve process or to serve documents? That is our first question. Is a constable authorized by law to serve documents or process? Right? No, the answer is twofold. It is both yes and no. However, the constable serving a document, right? It has a specific requirement in order for it to be valid. Remember, you know, them can do whatever them want. Them can go out there and they can decide, say, here we go on. I don't want nobody stop on the road here. Anybody who stop on the road here, I go arrest them for not following the orders of a police constable. Failure to adhere to a lawful order. Right? They can do whatever they want. It is up to you what you do after these actions have taken effect. All right. So that is the first question, you know. Can a constable issue process? Can he serve documents, especially where he's a witness? Especially where he's a witness. Is that what the law says he's supposed to do? That is the second question. Does the law say the police constable can serve process and issue tickets? First things first. Let us see what the law says. Okay? So, this is the Constabulary Force Act. Famous section 13. Right? For those who are new, we're going to do a small reading. This is one sentence, you know. The entire section 13 of the Constabulary Force Act is one sentence. There are no full stop in between this thing. So it has to be read as one. The duties of the police under this act shall be to keep watch by day and by night, to preserve the peace, to detect crime, apprehend or summon before a justice persons found committing any offense or whom they may reasonably suspect of having committed any offense or who may be charged with having committed any offense. To serve, remember, you know, I just ask you this, you know. Do they have the authority to serve process? Right? To serve and to execute all summonses, warrants, subpoenas, notices, and criminal processes issued from any court of criminal justice or by any justice in a criminal matter. And, so you know, so this is separate, right? When I say and, it is a conjunction, meaning it is joining two separate subject matters into one. So, the law actually says that the police can serve summonses, warrants, subpoenas, notices, and criminal process. But more importantly, it never says the constable can just do that by himself. Right? It says issued from any court. Issued from any court of criminal justice or a justice in a criminal matter. So the police cannot act on their own. When it comes to service of documents, it doesn't matter what it is. Whether they want to call the ticket a summons or they want to call it the ticket a fixed penalty notice. It is a form of notice, right? It requires that the ticket or the paper or the notice or the summons be issued from a court of criminal justice or a justice in a criminal matter, which is what? A judge. So if the court did not authorize the constable to execute that summons, that warrant, that subpoena, that notice. Isn't that a violation of law? Right, unless the constable is a judge, but then you would have a conflict of interest, a violation of the separation of powers. So if the constable issued a ticket, the first question is, who authorized the constable to issue a ticket? Right? Because the law specifically says if they are going to call the Constabulary Force Act the law specifically says all, right? To serve and to execute all summonses, warrants, subpoenas, notices, and criminal processes issued from any court of criminal justice or justice in a criminal matter. So which court or justice in a criminal matter authorize these constables to be issuing tickets? This is not something we are coming up with. This is what the law says. Since you want to stick to the law, you want to be lawful, please provide. True Name said traffic infractions are not criminal offenses. Wow. Well, sir, I think you need to do a little bit more reading. Okay? You are squarely incorrect. You can ask any judge when you go into a traffic matter, ask him whether or not this is a civil or a criminal matter, and he will surely tell you that it is a criminal misdemeanor that you are in court for. Okay? All traffic offenses are considered criminal offenses. So don't think that just because it's a ticket, you can't go to jail. Anyways, so if they claim you committed an offense, the first cause of action is to what? Apprehend or summon you before a justice. So when you say apprehend, what does it mean? Take you into custody and bring you before a judge. Summon. What summons mean? You are served a summons and you have to show up to court to answer in front of a judge after you get a summons. Right? So apprehend or summon before a justice. That is what is supposed to happen. Right? If you committed an offense. So why are you given a ticket? Why are you given a ticket instead of you being brought in front of a justice to answer for that so-called offense? Very interesting. And this is now commonplace practice. Right? It says, sir, you are speeding. Sir, you are speeding, so therefore you are getting a ticket. No evidence is provided, no opportunity to answer the so-called allegation in front of a proper authority, the judicial branch of the government. But yet still they are quick. They are quick to take out the machine and print off a ticket, tell you if you go pay it. You can pay it at the tax office, you can pay it at the Island Traffic Authority, you can pay it down at the courthouse, you can pay it, yes, you can pay it, yes, you can pay it, yes. But yet still, the law does not authorize them by themselves to issue any of these things. Okay? True Name said, does the Road Traffic Act cover this? Yes, it does, as a matter of fact. The Road Traffic Act gives you similar legislation. You want to take a look at it? Who want to see what the Road Traffic Act says? The Road Traffic Act of 2018. Let us go down to section 105. Let us read section 104 first, because it is actually section 105. Remote tours, lawful, always. Welcome, Moonlight Queen. Section 105 of the Road Traffic Act 2018. Subject to subsection 7. This section shall apply to any offense created by this act or the regulations and punishable on summary conviction, being an offense A. committed in respect of a vehicle by 1. it being left or parked on a road without lights or reflectors as prescribed. 2. is obstructing a road or waiting or being left or parked or being loaded or unloaded on a road. Or 3. the non-payment of the charge made at a parking place. B. specified in the first schedule. C. specified in the regulations as being subject to a fixed penalty. All right, so this is the criteria for which they are claiming punishment by summary conviction. All right. Section 2 states, 105.2, where, I can't see this. Let me bring it over some. Where a constable has reason to believe that a person is committing or has committed an offense referred to in subsection 1, the constable may issue to the person, or in the case of an offense detected by such electronic means as may be prescribed, issue to the owner of the vehicle the prescribed notice in writing, offering the opportunity to discharge any liability to conviction of that offense by the payment of a fixed penalty. Right? Or, people, what does or mean? What does or means? Does that mean that it can, excuse me. Tell me, those of you listening who are on your phone, what does the word or mean? Okay. An alternative option, not the same. Exactly. One or the other, not and. That is correct. Optional. Right, you have an option, one or the other. Right? One or the other. So it says, offering the opportunity to discharge any liability to conviction, right, of that offense by the payment of a fixed penalty. Or summoning the person to attend the court indicated in the prescribed notice to answer to the charge outlined in the notice. So let me ask you a question. If it says you can be given option A, which is the opportunity to discharge the liability, which means you can pay it, right? Or B, summoning the person to attend court, right? Why does the ticket have both of them on there? Why? The law, if we're going to consider the Road Traffic Act the law, right? It says the prescribed notice should put in writing offering the opportunity to discharge, or meaning only one of these options should be on the ticket. And in fact, the constable has the option of issuing only a summons, or he can issue a fixed penalty notice. So if the law states, if we're going to consider the Road Traffic Act of 2018, the law, if the law states that only one of these is supposed to be on the fixed penalty notice or the ticket, then why do we have both on there? Is that still a valid document? They can explain all they want. The law, the statutory law, is paramount above all explanations. Whosoever you're talking to, they can assume and presume and explain and declaim and do everything what them want. But at the end of the day, only what is prescribed by law is lawful. The law does not require explanations. If the law is ambiguous, it is up to the court to clarify a matter as it relates to the law. So the question is, so the courts are complicit with this oversight then, because the courts honor these tickets. You cannot make that blanket presumption, because the court will only consider what is brought before it. So whether you are on the offense or the defense, the court will only consider the evidence and the arguments that are placed before it. So it is the ignorance of the people that is causing some of the problem, right? You cannot always blame the court. If you go in there and the first thing you do is pleading not guilty, the court knows you don't know what's going on. So they proceed as necessary. Now, don't get me wrong. I am not on the side of anyone. I am on the side of what is lawful. That's why all my videos are about sticking within the confines of the law. But that being said, that does not mean that when you have an error in law, when you have blatant violations of law, that does not mean that the court should not acknowledge those errors and make corrections as necessary. Right? The point of the law is to ensure that everyone is afforded the same treatment, equality of the law. If the law applies to me, it should apply to you the same way. Right? So, the same thing we just went over in the Constabulary Force Act, it is the same exact thing that is in the Road Traffic Act of 2018, Section 105, 2A and B. Right? Now, let us talk about this guilty or not guilty plea that a judge is asking everybody, right? It is now a common procedure for those who are contesting their ticket. If you did not notify the court ahead of time with documentation, you did not notify the constable that you are contesting the ticket, right? You face the judge, and the first question the judge asks you is, guilty or not guilty to the charges? Right? And we went over this before, but some of you may not have been here. When we go to the Constitution, Section 16.5, due process, right? Are guilty with explanation. Right. Section 16.5 of the Constitution, Order in Council 1962, as amended, states, see if I can zoom in a little bit more. Yeah. 16.5 states, every person charged with a criminal offense, and we already established that a ticket is considered a criminal allegation. You're claiming that you committed a criminal offense. Whether you want to call it a a minor crime or a petty crime, it is still considered an offense or a crime. They are both synonymous. They mean the same thing. Every person charged with a criminal offense shall be presumed innocent. Innocent. It never said not guilty. Innocent until he is proved guilty or has pleaded guilty. Where in this body of law, and if you can find it anywhere, please direct me to such. Where in law does it states that a valid, lawful plea is not guilty? Because the Constitution already etched in the stone of law, because the Constitution is one of those things that is the hardest document to change. Okay? It is typically the sealing of law in a country. The Constitution here declares that every person, he said, every person charged shall be presumed innocent until he is proved guilty or has pled guilty. So unless you say, Your Honor, I am guilty, that is the only way they can treat you as having pleaded guilty. Right? That's the only way. Or if you are proven guilty after a trial. Right? So there is no option here for you to say, judge not guilty. It is the basic presumption of law. And it is written in law that you are innocent, regardless of what anyone says, regardless of what anyone presumes, regardless of the charges that are brought forth. You are not supposed to be pleading anything unless you are pleading guilty because you know you did the thing, right? But it is the burden of those bringing the charge or the claim to prove the charges or the claim. It is not up to you to prove you are innocent. That is the default. So when the judge is asking you guilty or not guilty, that is a violation of your constitutional protection. 16(5) of the Constitution expressly states you are already presumed innocent. So you're not supposed to go in there a plea. That is a violation of the constitutional protections afforded to every single Jamaican who is lawfully in Jamaica. Point blank. No exception. So the question now comes in where you reach in front of the judge and you say, Judge, according to section 16(5) of the Constitution, I am presumed innocent, and that is what I will stand by. And the judge say, well, sir, the two pleas that this court will accept is guilty or not guilty. Yes, the Constitution says that, but you have to make a plea. Your Honor, can you please state what body of law states that I must enter a plea? It's that simple. Honorable Court, can you please direct me to the specific law that states that I must enter a plea of guilty or not guilty? You don't have to argue with the judge, and I don't advise you or encourage you to do any argument with anybody. The first one is never argue with the officer on the side of the road. It cannot help you. In many cases, you just waste more time. Worst case scenario, they'll lock you up for the night. Or longer sometimes. So you don't argue, you don't explain. Never try to explain yourself out of scenarios. I mean, in some cases, it's very simple, right? You can say, a liar tell, me have my dash cam, right? You can say, well, if that is what you believe, then my dash cam will prove otherwise. Go ahead and do your job. It's that simple, right? But you don't argue. You don't go back and forth with these people. You simply, again, the police has their power on the road. And they really don't have that much power anyways. It's just that most people don't even know what the police is supposed to be doing. And I'm strictly talking about traffic here. I'm not talking about those that go for, people who are later found to be criminals. Because again, the police, I have come to see, love to label people criminals. Love labeling people criminals, and it is only the court who determines who is a criminal and who is not. So unless the court already found someone guilty, that person is not a criminal. And that right there is that is a violation of your reputation. Okay? There are other legislations that talk about pleas, but it is only in relation to someone who wants to plead guilty. It is never in the affirmative for someone who is innocent. Your innocence is presumed regardless of whether or not you open your mouth. Okay? Even in the Criminal Justice Act, it specifically states, even when one refuses to plead, you are to be presumed innocent and challenge the charge automatically. Because otherwise, we already see the abuse of power already. Imagine if they could presume that you are guilty. It would be anarchy in the streets, anarchy in the courts. Okay? So, it is simple. It is simple. Always ask the judge. If you're on the side of the road and you want to ask a question, it's a constable. What law am I violating? Right? Sir, you were speeding. Sir, you didn't stop at the stop sign. Was someone injured? Was someone's life in danger? The first thing I'm going to tell you, sir, me I'm a liar. Okay? You commit an offense, I'm going to write you a ticket. You don't argue with them. The constable on the side of the road can't give you no remedy. You bring them to court. You challenge your ticket in court. You prepare your proper documentation before you get to court, so you don't argue with the judge. Do not argue. How much time I tell you that? No arguments. Okay? So, again, what if the person wants to enter a guilty plea? Listen, if you feel that the charge is justified, you don't waste your time going to court. You just pay the ticket. The point of going to court is to challenge something. It is because you don't agree. If you already agree, you just go pay it. There's no reason to go to court. Unless I'm missing something. If you just want to go to court to go argue with the judge, well, that is your that is your contention, but I would not do that. Because sometimes, the court can impose a greater penalty if you are coming there to argue and then plead guilty. Right? So, if you don't know the law, those who know the law will always take advantage of you. Right? This is why we say come to class. Because if you don't know what you're supposed to be saying, what you're supposed to be doing, especially before you get to court, you're going to end up in there and you're going to get into a verbal battle with the judge, which you can never predict what the judge is going to ask you next. Never. Even though you might preempt some of the questions, you have to have a solid mental foundation when it comes to these principles. For example, if I went to court for any matter, just because I know what the Constabulary Force Act says, you think I am not going to print this out and bring with me? You think I am not going to send in my objections? You think I am not going to prepare my subpoena to ensure that the constable shows up day one? You think I am not going to put in all of my objections and all of my preparations and my interrogatories, all of my questions that are needed to ensure that if I do need to plead, all of the evidence and the details are necessarily in front of me before the judge asks me foolishness? It is necessary to know your playground before you start. You don't go into court trying to improvise as things go along. You prepare by reading the law first. Okay? A police class? I never heard of such a thing. And if there is, I don't think the public is invited. No, a class is for those in the public, those individuals who wish to learn more about the law and how they can properly benefit from lawful education, right? That is what we mean by class. So, when we talk about class, you have to be a signatory, right? And being a signatory means you go to voiceofjamaica.com. This is what the website looks like. And you click on the signatories link right here. And this section here informs you what it's all about when we say signatories, right? You can read the information here. You can see the public rights activation. And if you so choose, you can fill out the form and go through the process of becoming a signatory. Once you are a signatory, then you would have access to the classes. Classes over here. So if you click on class in the menu, right, you see all the classes that are available, right? Several classes, right? And as you can see, the price for all of them is free. There is no charge for any class. You just have to be a signatory. Now, for example, traffic and court class, which we're covering some of the basic topics here, right? We see we have 17 lessons, right? It would take you about 3 weeks to complete if you're watching one class a day, right? And the classes are quite lengthy. So, for example, class 1, if you are not a signatory and you click on this, you would notice that the content is restricted, right? So you have to be a signatory and be logged in order to access the class material, right? So if you are a signatory, you already know how to log in, right? Here we have different classes. For example, here's a traffic ticket remedy without going to court. We talk about those things privately. Some of these things we obviously cannot talk about in public. We cannot talk about these things on TikTok, or the page would be shut down, because these topics require extensive explanations. What's the RTA? RTA stands for Road Traffic Act. However, you have to be clear. The Road Traffic Act of 2018 is the current Road Traffic Act. The Road Traffic Act by itself is not a legislation. So what you see on the top of your ticket is an invalid reference of law, regardless of what anyone wants to claim, right? So RTA means Road Traffic Act for short. So as we've seen, Section 105(2) See, Section 105.2 of the Road Traffic Act of 2018 specifically states that your ticket should only have one of two options, either or. It's either a fixed penalty or it's a summons. And it doesn't matter which one you choose. They both must come from a court. They must. You see, it's a and to serve and to execute all summonses, warrants, subpoenas, notices, and criminal processes issued from any court of criminal justice or by justice in a criminal matter. Okay? So, these tickets have so many things that could be challenged regarding their issuance and enforcement. You should not be going in there arguing. You just bring the page. Matter of fact, this entire thing, Section 13, you can also bring Section 105, showing the law. You know, this is not something that you are arguing. You're basically stating, showing what the law says. And it is up to the court to determine whether or not that law applies and how the law applies. No, I am not an ex-police. Nope. I have never been a government employee and do not aspire to be as such. Same thing in the Constitution. Okay? Every person charged with a criminal offense shall be presumed innocent until he is proved guilty or has pled guilty. This is not something you come up with. This is something that is already in the body of law. Section 16(6)(f), same thing. You shall not be compelled to testify against yourself or to make any statement amounting to a confession or admission of guilt. Right? What is a plea? A plea is a confession. Not guilty. So now, if this is the case, where you should not be compelled to testify against yourself, right? Where does the judge get the authority from to force you to enter a plea in regards to yourself? The Constitution says I am innocent already, so why do I need to tell the court that I am innocent? What is a not guilty plea? A not guilty plea is not defined in law. It is a procedure of court. And I've had this question a couple of times. What's the difference between legal and lawful? Legal is what is currently being used by a government official. It is presumed to be in alignment with the law. That does not mean that it is in alignment with the law. Obviously, if you don't have checks and balances, people are always going to take shortcuts. It is the shortcuts that we normally feel as oppression in society. Right? So, if you are not to be compelled to testify against yourself, let me ask you this question. Where does a constable get the information from to write a ticket? The constable does not know you from Adam. So where does he get the information from that he puts into the system or into his device to print out a ticket? The primary source is what? He demands your driver's license. And whose information is on the driver's license? If it is my, let us use my, let me just use myself as an example. If I am pulled over and the constable say, sir, driver's license, please. And I say, constable, my private information is on the driver's license. And the constable, I got to tell you, say what? That is why I want it. Because I get a ticket today. You think I am going to argue with him? No. I am certainly going to give it to him. But guess what? That is a violation of my private property, my private information. That information is given under the threat of deadly force or punishment if I do not give it to him. Okay? Regardless if the card is for the government or not. That is my personally identifiable information. Right? So the driver's license obviously is not ours. Right? We did not produce it. We did not create it. So regardless of whether or not the information is on there, it is property of the government. So the card itself is for the government, but the information that identifies an individual is information that is protected. You see, all of these things are not in one place. So that is where a lot of people trip up. You're going there talking about guilty or not guilty when there are 10 other things to consider before you even talk. My private information was not authorized to be used by the government, nor the constable, nor anyone. So the data privacy protection, what? It does not apply to me? I don't care which act the police used to stop me. It is typically under the Road Traffic Act. However, whatever the police is out there claiming that they are using to stop me, unless there is a valid criminal matter that the constable is investigating, the police have no right to stop anybody unless it is of a criminal nature. I know some people don't agree, but whenever we speak over here, it is in relation to the law. Why do we say it have to be of a criminal nature, right? The police cannot see a criminal vehicle coming down the road. So therefore, most of the time, it is impossible for the constable to have stopped someone related to a criminal act. Right? Says, Constabulary Force Act Section 13 again says, but it shall not be lawful to employ any member of the force in the service of any civil process. So if it is not of a criminal nature, the police cannot stop any car. And we all know, unless the police, before stopping the car, has information. Mr. Alexander says, him can use reasonable suspicion under the Firearms Act, the Predial Larceny Act, the Customs Act, or the Constabulary Force Act. Right. Well, that is true. Let me ask you a question. How can reasonable suspicion be used to stop a car? Right? What do you see or what information do you have to stop that specific car? What information is a constable using to stop a specific car? That is the question. And again, it's because a lot of people are not familiar with cross-examining the constable. when challenging their tickets. There are so many things. There are so many things in front of that constable. He better make sure that when he claims to have stopped the car under any of those acts, that he has that information. Because unbeknownst to many constables, the same acts that they are using to stop a car and claim that, oh, we're using the Firearms Act, we suspect that this vehicle may be carrying a firearm, and we need to do a search of the vehicle. Right? If it turns out that no such information existed beforehand, and the constable is not able to justify with specific information what information he used, a radio call is not a valid source of information unless it is recorded and can be provided to the court to substantiate that so-called stop. Right? So it would have to identify the car, the make, the model, where exactly the car is traveling at the time, you know, specifics about the car, and whether or not, you know, any other information exists. So if the constable is not, right, the plate as well. If the constable does not have that information and you say, oh, we just get a call, so this look like one of the car we are look for. One of the first problem the constable is going to face is that is now called malicious prosecution. If them ever take out nobody out of a car or touch you, now that is assault and battery, especially if they lock you up. Now you have false imprisonment, especially if them tell you say you're a criminal. Now you so it's just because most people that end up in a bad situation, they might not know how to argue their case or how to proceed. Right? Even the offering of bail. The offering of bail is something that, again, many people don't even look into. But the entire police station is implicated and cannot offer you bail. You're supposed to go in front of a judge immediately if you are being apprehended or brought outside of your comfort zone, which is outside of your car, and being taken to the police station and all them something. You're not supposed to be offered bail by anybody in the station. And as a matter of fact, the JPs who are typically offering people bail in some of these situations, they are not authorized to be offering bail either. Who tell me that? Who tell me what? I can bring up everything that I am saying in law. So be very specific with your question. Anything you hear me saying, I can bring it up in law. So that will not be a problem. Right? That is true, Mr. Alexander. However, that is under some acts. It cannot be related to traffic matters. In most cases, it has to be either a petty offense or under some sub-law. It is very specific in the Justices of the Peace Jurisdiction Act and also the Justices of the Peace Act. Right? And even here, where it talks about a justice, right? Any justice in a criminal matter. Do JPs conduct criminal proceedings? Do JPs conduct criminal proceedings? So that is exactly what I said. A JP cannot La, la. This is why we say come to class, okay? If you don't know the law and you go off of the presumption that everybody is following the law, you're always going to lose. Those who know the law think they are superior, especially if they work for government. Even the basic front agent, the frontline agents who are sitting at a desk taking down information, they have some kind of superiority complex where they think that everybody else is stupid. They think nobody else knows the law and whatever they are doing is the right way. Right? So when somebody comes around doing something different or demanding something different of them, they feel that these people are trying to make their lives difficult. They're trying to make people's job difficult. When they don't know their actual job is on the line when they cross the wrong individual. Because when it comes down to it, people, it is not what was done. It is what can be proven as a matter of law. So you see, when time these little agents and these people who claim that this is the law and that is what the law is, you say, can you please inform me of which specific law you're referring to? The first thing them I going to tell you, sir, me and a lawyer. I just know that this is what the law says. So if you're a lawyer and you can't point me to the law that you're referring to, I am supposed to just believe you? I am supposed to just get up and say, yeah man, okay, I must so it go. I have many examples of it. Many examples. And you see, when people realize that you're not messing around, that's when they might try to friend you up. And that's not how it works. Okay? When you go too far as a public servant, don't expect people to have leniency with you. Yes, you see, the constables are one thing, Some of them little disrespectful. Many of them just want to get over with them there. But I am going to call out the customs officials. I don't know for what reason, but them feel like them are God on earth. They don't want to hear no explanation of nothing. It don't matter which part of they have one window. You approach them individually. It don't matter which part them they. Them act like say, whatever them say, I saw it go. And you know if you question it. That's why I love write down their name, And that's why you see them change them around so often. Because when them get too complacent, that's when they get themselves in trouble. Because oftentimes, they have no idea what any of the law is. When you bring documentation, some of them don't even want to look on it. They might tell you otherwise. And then, when they start facing the fire of the court, they're ready for beg and plea. They are no longer this fired up agent. No, they are a humble servant. The time gone. The time passed long time. When them out there and make everybody life hell, they don't have no leniency. Some of them will tell us, say, oh, you think fear head bigger for me? You think say you smarter than everybody in here, so? I saw them deal with people, But you see when time people start bring the fire to them tail, then quick for tell us, say, me did just do my job. Me never mean anything. But whenever they feel like you don't have any power, they treat you in such a deplorable way. Especially when you're asking them a lot of questions. So, when them get prosecuted, Me no sorry for none of them. The same way them out there prosecuting people, the same way them out there making people life hell, is the same attitude you have when time you get sanctioned by the court. When you see you get served with a subpoena, say you are demanded to be in court or you'll be found in contempt. Right? You can't sorry for them. Them just do them job, so make them do them job the same way all the way through. This is why I teach them something in a class. I can't teach it right as well. But that is why I go in all the details in class. You can ask all the questions you want. You can bring up all the things in the live group. Right? So when you have your situation, you know how to deal with it. The same thing goes for the constables. When them out there and them act like say, hey, whatever me say, that's the law. Have the same energy when you go to court. Tell the judge that too. Tell that to the judge when it is brought up. You said you are the law. Show us where in the Acts of Parliament it states that you, Constable XYZ, is God. Yes, man. No. Let us scroll up a little bit here. Right? Where we have the oath. Section 4 of the Constabulary Force Act. Right? In case you never know, this is what the police must swear to before they become a constable. Says, I, A, B. First name, last name. Do swear that I will well and truly serve our sovereign lady the queen in the office of constable, without favor or affection, malice or ill will, and that I will see and cause her majesty's peace to be kept and preserved, and that I will prevent to the utmost of my power all offences against the same, and that while I shall continue to hold the said office. So when you hear me say the office of a constable, right? That is the position that the constable holds and enforcing from. Right? So when he out there say I'm a constable, that is called the office of a constable. Little to the left. Right? While I shall continue to hold the said office, I will, to the best of my skill and knowledge, discharge all the duties thereof faithfully according to law. So help me God. You see it say? According to law. Let me zoom it in a little bit. Right? It never say according to what I feel is just, it say according to law. What else does it say? It says without, see, it say, I swear that I will serve the queen without favor or affection, malice or ill will, and that I will see and cause her majesty's peace to be kept and preserved. Right? So let me ask you a question. When a constable tell lie, isn't that an ill will? Alright, let me take down the boxes because when I have no questions right now, so I can see it properly. Is that better? Okay. When a constable tells a lie and you catch them in the lie, isn't that an ill will? Isn't that something conceived of a negative or nefarious nature? So isn't that now a violation of the very oath that was taken in order to become a constable? This is what you call fruits of a poisonous tree. fruits of a poisonous tree. You may have heard this in American law. But this is where it has to come from. The root and foundation of the authority. That is how you have a poisonous tree. Meaning everything that comes from that tree is compromised. So when it is said that a constable can lie in order to get a confession, it is a lie in itself. It is absolutely not true. Because that is a direct violation of the oath that is taken. And that oath is what? That oath is unlimited as long as that individual is a constable or exercising the office of a constable. This oath is in effect. So in can't say him off duty at the time and him get a confession. It doesn't work so. Once you catch them in a lie, it collapses all jurisdiction because it is a violation of the oath that was taken. But first you have to find out whether or not he even has an oath or she has an oath. And once they have an oath, you procure it. You demand that it be produced. And you put it in front of their face. And when they get caught in a lie, you bring up this very point. Was that a good will or was that an ill will to lie while you are under oath? Tell the court, explain to the court what that is. Once this admission is taken, you can demand sanctions. Credibility has been cracked. Cannot be amended. So this is why I say this many times. It is better to read 1 page a day or 2 pages a day than to sit down there thinking that you have one magic bullet and that is going to win your case. Yes, in some cases that might be true. But in other cases, you have to have all of the ammunition in the magazine. You can't rely on just one fact because in some cases, the court will try to proceed as if the issue that you raise is not fundamental to the case. So you have to be prepared from the start to bring the matter all the way through. But this right here is how you establish that the entire proceeding is lack of jurisdiction. The court cannot acquire jurisdiction where you have a violation of the very oath that was taken by the authority to be exercising their power. Okay? So, again, a constable cannot issue a ticket unless he gets permission from the court to do so. The amount of time we go over Section 13 of the Constabulary Force Act. Come like our motto every time we go live, don't? It is so important to comprehend the entire Section 13 of the Constabulary Force Act. I have to keep going over it. Have to keep going over it because if you bring this up during a contention, exactly, out of a constable. If you bring this up as an affirmative defense, most likely your case, your ticket is going to be thrown out. Okay? Most of it cannot stand. A matter of fact, none. None of these tickets cannot stand if you properly understand Section 13 and Section 4 of the Constabulary Force Act. My brother, you're dropping a dime. This is what you call real knowledge. Well, knowledge is one thing, brother. But I want it to be converted into wisdom. I want it to be like the back of your hand. You don't need to go look in a book when you're ready. It just come off of the cranium. You see it? So while this is great, it is better in practice. But yeah, man, thank you for the compliment, you know. So let us talk about bail. Where is the brother who did bring up bail? Him still there? We talked about bail before, but I'm going to get into it a little bit. Mr. Alexander, you still there? Drop a comment if you're still here. So we're going to cover your topic now. The last question you asked was whether or not the constable can offer bail, right? So here we have the Bail Act of 2023. Adrian said you would need to start having real class. It's special for the driver in Jamaica. Well, we have class, but una not come a class. Una like to be entertained on TikTok. All right, so the Bail Act of 2023. All right, we went over this last time, but let us take a closer look at the Bail Act. So it says this act may be cited as the Bail Act 2023. In this act, arrested includes apprehended, right? So once you are not free to go, you are considered arrested. Okay. You know, sometimes I say some things and people are quick to say, for example, a ticket is not a conviction. If the police stop you, that is not an arrest. It is a detention and it is this, it is that. Like I said before, anything that I am teaching here or anything you hear me say, I can back it up with the accompanying law. Okay, so it is not just me saying things to say it. I can completely express in full what I am saying as it relates to the law. So here in the Bail Act, it specifically tells you that you are arrested once you are apprehended. Once the police stop you, you are arrested. Okay? A bail center means any facility declared by the minister pursuant to Section 20 to be a bail center for the purposes of this act. Child conviction includes a finding of guilt. Okay? So, when I tell you that someone that is considered a criminal has to be convicted by a court first, it is not just me saying that. The courts have said it many times, and the law also said it. Okay? A conviction for someone to be a criminal, you have to have a finding of guilt. A finding that a person is not guilty by reason of insanity. So even when somebody is found not guilty, it is also a conviction. A conviction for an offense for which an order is made, placing the defendant on probation or discharging the defendant absolutely or conditionally, is also considered a conviction. So even those that are found innocent, it says, discharging the defendant absolutely or conditionally is also a conviction. So once you are brought before a tribunal or a court, anything that happens thereafter is considered a conviction. It is right there. It's not me saying this. It is what is written down. Okay? All right. Deciding official. Oh, Mr. Alexander, you're back. Okay. No, first we're going to address your previous question about the officer granting bail. Deciding official means the court, judge, justice of the peace, or constable, as the case may require, who is the competent legal authority on the matter of the grant of bail or any question related thereto pursuant to this act or any other law. In the case of a constable, shall not be the arresting officer or an officer involved in the investigation of the offense concerned. And we are only in the definition section. So I hope you're paying attention. It specifically states that a deciding official as it relates to the Bail Act of 2023. In the case of a constable, shall not. What does shall not mean? Shall not. Shall not. What does shall not mean? When we talk about the law or the courts. Shall not means it shall be impossible. Don't do it. Must not. You have no option. Okay? Shall not, or right, never, shall not be the arresting officer or an officer involved in the investigation of the offense concerned. So let me ask you a question. If you get arrested and you are brought to a station, which is typically what they do, right? This is the typical process. They arrest someone, they bring them down to the station, you are offered bail, right? Isn't it typically a random officer in the station or the officer will charge you? For those who have been through the process already. It is typically either a constable or a JP that come in there offering people bail. But here it specifically states, it shall not be the arresting officer or an officer involved in the investigation of the offense concerned. So my question is, once you go to the station, right, and you have an officer giving you, a constable in most cases, giving you the option of bail, right? So you need to sign documents and they're going to give you a condition to come to court and blah, blah, blah. How do we know that this officer is not involved in the investigation of the offense concerned? How do we know? The first thing is this. If you ever bring up the contention that bail was violated because the officer offering you bail had knowledge of the arrest, that bail becomes invalid and the case cannot proceed. It is the burden of proof of the official, the constable. It is the burden of proof for the constable to prove that the deciding official was not involved in the investigation or had any information regarding to the so-called offense that you were arrested for. It is not for you to prove. You simply object to it. You simply state that you demand proof that the officer who offered bail had no knowledge of the investigation into the matter. You demand the court. This is for when you go to court. The damage has already been done. Oftentimes you are in a station, you don't have any recourse. There is no one there to offer you any kind of restitution. So you just have to ensure that you remember the details and write them down as soon as possible. Right? So, the deciding officer, you see it say, in the case of a constable, shall not be the arresting officer. So if you notice, they call a constable an officer here. The reason they say that is because all officers of the force are first a constable, right? They have the power of a constable, but not all of them are in the office of a constable. Some of them are superintendents, some of them are district constables, some of them are this, that, whatever, sub-officers. So, regardless of the rank, they are all constables, right? But it cannot be an officer who has any information regarding why you were apprehended. Okay? Defendant means an individual who is charged or convicted of an offense, or detained or arrested for an offense, or for whose arrest a warrant endorsed for bail has been issued, and who has not yet been charged with the offense. So once the police stop you, you are now a defendant. Again, this is what the Bail Act of 2023 states. This is not just me saying that. So these are becoming more serious by the day. Right? But does not include an individual committed in default of payment of any sum of money, blah, blah, blah. Again, the reason they put this is because what? It shall not be lawful for any constable to be employed in the service of any civil process. Sums of money, payment for sums of money are civil. They are not criminal. So that's why they put this exception here to fall in line with the Constabulary Force Act Section 13, the latter, right? It shall not be lawful to employ any member of the force in civil process. Right? So back to the Bail Act. Offense includes an alleged offense. So even when they tell lie upon you, it still includes an offense. Judge means a judge of the parish court, a judge of the Supreme Court, or a judge of the Court of Appeals. Now, interesting here, right? How come we don't see a definition for justice? Interesting, don't? We have defendant, we have judge, we have offense, we have surrender to custody, and we have the prescribed record. But we don't see a definition for a justice. All we see here is something in relation to a judge. Judge of the parish court, judge of Supreme Court, judge of the Court of Appeals. All right. Surrender to custody means surrendering into custody at the time and place appointed to the prescribed record. The prescribed record means the record of a decision regarding bail made pursuant to Section 10. What does Section 10 says? Because them love reference other section without telling you what the hell it says. So let us go. Exactly. Section 10. What's Section 10 there? Those on skirt. 7. We've been here before. 9 and 10. Section 10. Recording and giving information on decision concerning bail. 10.1. Subject to subsection 2, where a deciding official grants bail or refuses bail, appoints a time or place for the defendant who is granted bail to surrender to custody, imposes or varies any condition in respect of bail or revokes bail, the deciding official shall, in the form set out in the third schedule, make a record of the decision and shall cause a copy of the record of the decision to be given to the defendant and every person providing surety in a case where surety is required on a condition of the grant of bail, and the prosecution, or in the case of defendant who has not yet been charged, to the police, as soon as practicable after the record is made. Where bail is granted, we kind of run past something there. So it says in accordance to the form set out in the third schedule, right? Where is the third schedule? Let us find it. This is second schedule, and this is the third schedule. So this is what the bail application should look like. How many of you ever seen something like this? This is the exact bail application. This is what should be filled out when you are offered bail, right? Now, interesting, remember, it never have a definition for justice, but it says if the deciding official is a justice of the peace, you need the name of the justice of the peace, the registration number, and the parish of registration, right? If it's a constable, the name of the constable, rank and identifying number. If it's a judge, name of the judge, and the court, right? So now, if you did not get this form in its entirety, right? And again, that is page 1 of it. This is page 2. It says reason for decisions concerning bail, right? So they have to give the reason, the finding that they had to have offered you bail in the first place, right? Or think that bail is necessary, right? And this is the second part of the bail application, right? Applicant's signature. No. Okay, that's fourth schedule. That is if you are appealing. Prosecution against grant of bail. All right. So that is section 10, right? Section 10 talks about the bail application. Now, something to note, right? And for those of you who have been to class, you already know how to sign already. So you don't need to worry about all of that, if you are forced into a situation like that. So another thing to note is that you don't necessarily need to fill out that application. And if you are forced to, if you don't have an option per se, there's always an option. But anyways, publicly speaking, you have the right to be released on your own recognizance if it is not a dangerous crime or involving any real criminal act, right? You can demand that you be released on your own recognizance. Now, people don't even know what the hell that means. That is the other problem, right? If you don't even know what that means, then you don't even have that option. You have waived that option. But as a matter of law, you are presumed innocent. So therefore, if the law presumes you to be innocent, the granting of bail should not necessarily be the first option. And you can opt to be released on your own recognizance, right? Okay, and self-bail. So you don't have to fill out that form. You don't have to apply for bail, right? You don't need a monetary release from custody. You can demand that you be released because you are not a danger to society. You intend to come to court and all of them something there. But you don't necessarily need to fill out a bail application to be released from custody where you are not a danger to society, or you are not, there's no evidence to show that you will flee or abscond, not show up to court, right? So this talks about children in the case of a minor. Subject to the defendant is entitled to be granted bail by a deciding official pursuant to a power to grant bail conferred on that deciding official under this act or any other law. So what is this saying? Entitlement to bail, right? It is saying that the deciding official, the grant of bail must be made right? The defendant is entitled to be granted bail by a deciding official pursuant to a power to grant bail conferred on that deciding official under this act or any other law. So the question is, does a constable have the authority to grant bail, especially the one arresting you? The answer is no. The arresting officer or any officer who was involved in your arrest or know anything about why they arrest you is not authorized under law to offer you any bail. Right? The question of bail to a defendant shall be decided in accordance with this act by a deciding official within 48 hours after the defendant is arrested. It never say close to 48 hours. It never say after 5 hours. It say within. So you can demand immediately that you be released on your own recognizance. Right? Bail is a matter of discretion when it is applied for. You know, must get it. But as a matter of the constitutional guarantee, right, of being presumed innocent, section 16.5, we just went over that as well. Section 16.5, every person charged with a criminal offense shall be presumed innocent until he is proved guilty or has pled guilty. So if you did not plead guilty, you have the right to be released on your own recognizance. Self-bail. Right? Within 48 hours after the defendant is taken into custody, consequent on being charged with an offense, and after the defendant having been convicted of an offense other than an offense listed in Part 2 of the first schedule. Right? In relation, hold on, how would this? Deciding official, right? So Part 1 of the first schedule, it says within 48 hours after the defendant is arrested or detained on reasonable grounds that the defendant has committed an offense listed in Part 1 of the first schedule. So the requirement here is reasonable grounds. What does reasonable grounds mean? Evidence. Evidence, not just testimony. There has to be corpus delicti, the body of the crime. I wonder if you not hear me. I wonder if you not did it. Bail is only available where there is evidence to support the reasonable grounds upon which the defendant has committed an offense. Signatories, we already know the elements of a crime are necessary. It is centered on my device. I am not sure what you mean, like so? D-boy, you can see it good now? Okay. Reasonable grounds is necessary. What if a warrant is out for your arrest? Can you plead not guilty or self-bail? Absolutely not. Not in my experience. If you have a warrant out for your arrest, what I would do if I was in that situation, I would go to court early one day and demand to speak with a judge or to see a judge regarding a possible warrant. Okay? That's what I would do. I would not wait for the police to find you. If you don't want to enter jail, that's what I would do. Yeah, you don't have to have a case to go down to the courthouse. You can go down there regarding a legal matter, a matter that concerns the court, and ask if there is a judge available to speak to regarding a warrant. I mean, you can learn about the warrant by looking up a ticket, looking up your name and information. You can call, you can contact the tax office. Many ways you can figure out that a warrant is out. It doesn't have to be you get arrested by the police. Right? That is an unfortunate situation. You know, I have actually had that situation happen to me, you know. Which again, it was I had an overseas license and I presented it to a police, and somehow he put in the number in the system and he claims that a warrant was out for my arrest. And I said, warrant out for what? What was the charge? Him say, up on the North Coast somewhere there. I don't remember. I think Trelawney or one of them place. I had a ticket back in, was it 2017 or some crap like that. And I say, since 2017, and I every time, if I am ever pulled over, I present the overseas license. So how can that not have been in the system? He say him not know, but it just show up, say there is a warrant. And he showed me. He showed me the screen that he was looking at, and it did say there was a warrant. And I say, well, I had no knowledge of that. You know? So he said, well, it is best that I go down to the courthouse one day and try to rectify it with the judge. But once they have that in the system, if they pull me over, the only reason he claimed he didn't take me into custody was because I had children in the car. Right? So, right, that was one of my questions. How can you have information on an overseas license when Jamaica does not have any systems that can communicate with an overseas system? There, you know, that doesn't exist. And the soldier, them we're ready to tell you that. If you have an overseas license, them just no bother. But apparently, they had that information in their system. And I say, okay, how did that even come about? But anyways, he said, listen, go and go take care, right? Because you have children in the car, we can't have you and the children in this kind of situation. So just make sure you take care of that. So, you know, there are situations like that where you find out and you had no idea about it. So it is best that you go take care of that as soon as you can, rather than wait for the police and carry you in, because most likely, if the if the constable decides to bring you in, you're going to probably spend the night in jail. Okay? And I don't know nobody who want to do that. I certainly don't. But at the end of the day, you know, sometimes you have to go through the process to ensure that, you know, you straighten up your thing. But by no means am I encouraging anyone to be a jailbird. So that's why I say, go down to the court. First thing early one day, they might deal with the matter and say, hey, you might just have to pay a fee, or you might have to rectify this, or, you know, come back for a trial. But they might just give you a date, so you come back to court and you adjudicate the matter and you get it over with. But again, do not wait to get pulled over by the police to figure out that a warrant is out. Yes, it can be a mistake sometimes. Then put in wrong number in a system and your thing end up show up. So, right. That's not legal lawful tires. Well, you know, you would have to argue that in court, whether it's legal or not. But you can go to the police and make arrangements to come in to be taken to court. But Debo, why would you go to the police when the police don't even bring you to the judge when he's supposed to? If it is not an emergency matter, the police is not going to take you in front of the judge to take care of the matter. They are going to lock you up. You have a warrant out for your arrest? They are, you see, go back to section 13, right? If there's a warrant out for your arrest, the warrant can only be issued by the court, right? So the police have the authority right there to lock you up. That is one of their primary powers, right? To execute all warrants. So if you go to the police, I mean, that's your option still. Hey, if you feel that is best, go ahead and do that. But I don't suggest, I would not do that. I can't suggest to anybody to do whatever. I just would not do anything related to the police, because sometimes you intend to do the right thing and you end up in a bad situation. So I would just go straight to the court, speak to the judge, or ask to speak to a judge and find out if you can have a date set to resolve whatever the issue is. That way, there is no reason for the police to come look for you or pull you over on the side of the road and figure out say you have a warrant. Anyways, back to the whole situation of bail, right? So it's a grounds within 48 hours after the defendant is arrested or detained on reasonable grounds that the defendant has committed an offense. So here it is saying bail can only be offered if you have committed an offense and they have reasonable grounds, meaning they have physical evidence to show that you have committed an offense, right? Listed in part 1 of the first schedule. In any case where such a defendant has not yet been charged because more time is needed to prefer charges, right? So part 1 of the first schedule. And here we have part 2 of the first schedule. So let's go look at the first schedule. Let's find the first schedule and see what they are talking about. All right. So first schedule, part 1. This is why, by the way, a justice of the peace cannot issue bail in most cases. How do you handle a case in a warrant issued for someone with the exact first surname and address? I have no idea. Again, discrepancies like that, go straight to a court. Whatever court it is, I would go straight there. So, it says, in order to grant bail, it has to be one of these things listed in the first schedule. So, first thing it say, unalive, right? So this is, of course, a serious crime. Offenses under section 2, 3, or 4 of the Treason Felony Act. Any offense listed under section 3 of the Malicious Injuries to Property Act, arson of a dwelling or house. Any offense under section 13 of the predial larceny or section 40A extortion of the Larceny Act. So these are the acts it is listing, Again, Offenses Against Persons Act. Right? Dangerous Drugs Act. What's that? Yep. So all of this are Dangerous Drugs Act. This is Trafficking in Persons Act. Child Care and Protection Act. Sexual Offenses Act. Perverting the course of justice. So if we go through all of these, right? Criminal Justice Act, Suppression of Criminal Organizations Act. Right? If we go through all of these, there is no mention of the Road Traffic Act. No mention of the road traffic regulations. Trafficking, manufacture of prohibited weapon, dealing in prohibited weapon, prohibition and diversion. Nothing here. So here's part 2, right? Again, unaliving. Firearms, Prohibition, Restriction and Regulation Act. Criminal Justice Suppression of Criminal Organizations Act, Law Reform Act. And that's it. So, so when the police pull you over, right, and they offer you bail, and it has nothing to do with any of those situations. Again, of course, there are situations where, you know, it is proper for them to so-called offer you bail. But if it is not within the gamut of the authority given here, say, part 1 of the first schedule or part 2 of the first schedule, right? If it doesn't have anything to do with these two sections of law where it is telling you what bail applies to, then the bail application is invalid. The offer of bail is invalid. You should have been released on your own recognizance. But if you did not read and you don't have any idea what this is or how it applies, you're out of luck. So, in the case of section 1, so he said the deciding official for the purposes of subsection 1, right, where it's talking about here, the grounds under the first schedule, right? So again, if it is something really serious, it says the deciding official, where is it? 2. The deciding official for the purposes of subsection 1, which is what we went through just now, the first and the second, the first schedule, part 1 and part 2. In a case falling within subsection 1A, shall be a justice of the peace. So it has to be within those sections of law for a justice of the peace to have the authority to issue bail. So in traffic matters, a justice of the peace has no power to issue bail. Or a constable at or above the rank of superintendent, right? So one of these two can offer bail to somebody in a serious criminal situation. In a case falling within subsection 1B, except as otherwise provided in subparagraph 2, shall be a constable, a justice of the peace, or a judge, right? Subsection 1B, within 48, 1B, right? Within 48 hours after the defendant is taken into custody, consequent on being charged with an offense, right? In the case falling within subsection 1B, except as otherwise provided in subparagraph 2, shall be a constable, justice of the peace, or a judge. In the case of an offense, listed in part 2 of the first schedule, shall be a judge. So, part 2, if something falls under part 2 of the first schedule, it has to be a judge. There is no option there. But the only thing I see there of an issue is that both of them listed unaliving as one of the criteria, you know, under that section. But anyways, like I said, for serious offenses, they have specifics here where a justice of the peace can offer bail. But the Road Traffic Act and regulations are not listed there, right? And this is an updated law. This is Bail Act of 2023. So this is not even something before the Road Traffic Act. This is after the Road Traffic Act was already, of 2018, was already implemented. So they could have listed the Road Traffic Act in here if, in fact, a justice of the peace had the power to grant bail, because that would also be in conflict with the Constabulary Force Act, right? Where it says what? Any person found committing or having committed an offense should be brought before a justice, to be summoned before a justice, right? And a justice here is specifically referencing a justice in a criminal matter, which is a judge as defined in the Bail Act, right? In a case falling within subsection 1C, shall be either the judge before whom the defendant was convicted or a judge of the Court of Appeals. Where in any case falling within subsection 1A, more time than is specified under section 1 is required, blah, 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 blah. Identification period. So, that being said, You cannot be offered bail for traffic matters involving traffic issues. The Bail Act does not support that kind of foolishness. Okay? So, do we have any questions? I'm gonna open up the panel again. Change up the panel this time. Do we have any questions? You can certainly come up and let me know if you have any questions. Zine? So when we talk about bail, when we talk about some of these issues, they have very specific requirements and criteria. It is not just anybody can offer you bail or them kind of things there. Patrick, I'll go on. So other than that, again, as I will always point out, it is better to know than not to know. You cannot go to court with common sense. You cannot assert a right under common sense. You have to command a body of law. Yeah, memes, I'll go on.
Bless up, lawful.
Lawful, always.
Just a quick question, not to really interrupt you, but just someone come across last night. You know it, Gary.
Yeah, man.
So last night while on my way home, right? Long traffic build up. Driving, all right, everything straight on the car, no need to worry, right? Almost past the police, past the first two police. Then now the third one right at the end. Pull over right there. Okay, all right, no problem. Pull over, right? Walk around the vehicle with his phone, I guess checking the license plate and everything. So turn off the light now. So he said, why you turn off the light? Help with your visibility, I guess. Understand? Because the light's bright on the car. All right. So I asked him what's the purpose for the stop. He said blue light on the car. Said blue light on the car. I said, where is that? So he said, right at the front. So I said, okay, hold on. So I pulled the seatbelt, went outside, right? Looked at the car. So I have a emblem, like the little the sign on the car. So yeah, that has like that has maybe like when I research it on what do you call that? On Amazon, it has like maybe 3 or 2% wattage, right? So basically, it doesn't really emit, as I was saying to the officer, it doesn't really push off a light. It's more just like a low background light. So if you don't really go there and look at it, it doesn't really, shine. So I said, if I put my hand in front of it, officer, you can't see it. So I don't understand how can this be something against the law where you have to directly go there and look to see that it is actually a light, because it doesn't shine. It's just a warm background light. All right. So he said, only police vehicles should have blue on it. I said, okay, but there must be some guidelines. He said, no, only police vehicle. All right. So I went ahead now and did some reading. So the ticket that he issued said, operating a motor vehicle with lamps emitting blue light or capability to emit blue light. So I said, okay. Yeah. So I went and did some research where it says, I was trying to find the exact one, but I'm on the road. Yeah, where basically it says, if your certain things only apply if the wattage of your bulbs are 7 and up, right? 7% wattage or whatever, and up. Hence, mine wouldn't fall under that. So I, just wondering if you could give me some further information on that.
Right. Well, that is a kind of a tricky legislation, because the purpose of that, which they were not specific enough, is the emission of a blue light was meant for the top or the side of the vehicle where the windscreen is. Obviously, those are the places where a police siren would be. right?
All
So
right. Okay.
if even if there is a blue light, right, it has to be something similar to what the police would use when they are in pursuit of someone or in an emergency or whatever the case may be. That is something, unfortunately, if they charge you for it, you have to go to court for. Right? You can't argue them out of it. But it is something simply explained. You take a picture of it, both in the night and in the day, and you go to court. I explain to the judge, did it come with the car or you fitted it?
It was fitted.
Okay. Well, you bring it and you explain the situation that, it was not in contravention because you were not operating in a manner that can be construed to be an emergency vehicle or to appear to be, a vehicle of the state or a JCF vehicle or a JDF vehicle or anything like that.
Exactly, because it's not even, sorry to cut you, but it's not even a flashing light where you can say then, okay, someone will see this and say, oh, maybe the police or what. No, it's literally just a warm background light.
Right.
That's it.
And most likely it's a very small light.
Yes, it is.
Right. So, that is just an abuse of discretion right there. It would have to be proven that you are trying to imitate or try to appear to use a blue light for emergency or law enforcement purposes to really stand. Something like that. That is, again, this legislation is very vague when it comes to the blue light thing. But, it is not something hard to beat. Because it would have to be proven that you were using it as the law intended.
Exactly.
Right. Mm-hmm. So that was, I guess him just want to do something there. So.
Yeah, because here's the funny thing about it now. Obviously, they were just out fishing last night because they stopped, while I was there, they stopped 4 vehicles. All 4 of us, different description of vehicles. So obviously you weren't doing any spot checks for, like, you heard something, a black car. My car is silver. The other car that they stopped was a white car, different shape. They stopped a Toyota, what's that name? The open back one, and they stopped a CRV across the road. So all different cars. So it's just random stops. So there's nothing in particular they're looking for. Just fishing.
Well, even though that might shed light on the circumstances of the stop, you couldn't. That is probably not something to bring up, but Vine of Hope says some judges may not accept any explanation. Remember, it's either you are guilty or not guilty. Also, because it was fitted depending on the road, on the mode, the judge may or may not entertain the reasoning. So here's the thing, right? If you plead not guilty, it is not your burden of proof to prove that you are innocent. That's not how the law works. It is always the burden of proof on the state to prove the evidence that they have to support the charge. So the only thing you really want after you plead not guilty, if you plead not guilty, if you do that, is to demand that either the Crown or the constable provide the evidence upon which they are relying upon. It is not you to prove that you were not operating as a police car or as an emergency vehicle or using your blue light on the car for some unlawful purpose. It is not your burden. It is whosoever is bringing the charge. So if you get into the contention with the judge and I try to explain, then that's where you're going to go wrong. You have to demand. Yeah, it's not you accusing anyone. It is those making the accusation has to prove.
Okay.
Right. Even the whole wattage situation, it is not your burden. They have to prove that let's say in the case that it is a lower wattage light and all of that. The state has to prove that they have verified and ensured that the evidence is credible enough to bring the charge. It is not your burden. You are not the one making the accusation. So regardless of whether or not the judge is trying to so-called entertain anything, that is not your problem. The law states that those who are bringing the charge are the ones who have to prove the case, not you.
And the thing about it is sometimes going to these Jamaican courts, oy, trust me, trust me, it's not always easy to deal with some of these judges, and especially when it's you and an officer. It's not always the easiest case.
Right, but this is why you learn bits and pieces of the law. So, specific to your situation, you look up what law applies and you try to you try to accommodate the situation like that.
Yeah. Because I remember the last time I was in court, I asked I'm trying to remember the question exactly that I asked. And I think it was in section 13. It was something towards headlamps. And I asked him like if the headlamps, like it was something to do with the visibility of the car, and they were like, no, it doesn't help with the visibility of the car. It's a distraction and some other thing that they went into. I just said, okay, you know what, forget it. Forget it. Yes. Like a lot of things can be distracting. Yeah. So.
LB. For add to a yard memes, I say, you hear me?
Yeah, man.
Alright. I don't know in a which act the definition of an emergency vehicle is, right? So I don't know which act define what an emergency vehicle is. But however, the road code book where when you learn to drive, it describe an emergency vehicle as police, ambulance or fire truck with siren sounding, right? That's the definition. So just for add now, one day me up on the road, right? And 3 Hilux, them unmarked. So them not have no definition whether them are police or whatever, you see me, because them unmarked. However, them have the flashing light in a them grill. There are a lot of vehicles in Jamaica like that right now, right? You don't know whether them are dignitary or whatever them is, them are diplomat or what them have regular license plate, and you will see flashing blue light in a them grill. You understand? And them are move too fast sometimes without siren, just the flashing blue light. So anyways, 3 Hilux are forced for pass me. 2 of them pass me already. And when the third one now a bore for come through, him a pass me on my left, I wind down my window. And when him get near to me, it's like him a try steer me down. So I say, your emergency vehicle? Him say, yeah. So I say, what oh, me not see nothing or whatever. So him a try show me say the first 2 vehicles them will pass me, they have the light a flash, which they did. So right away I clarify to him and said the road code book say with siren sounding and no flashing light nothing. So flashing light alone don't make your emergency vehicle, you need to have a siren. So when them a bore through on them thing there with just flashing light without a siren back it, if them cause problem, them wasn't an emergency vehicle under that circumstance, according to the road code book. Because the flashing light alone don't make you an emergency vehicle. Even if you is a police car and you just have on the light them alone and a siren behind it, you're still not an emergency vehicle. According to the road code book. I don't know if an act would have defined it separate from that, but according to the road code book, that's how it go.
Right. Well, that might be true, but when it comes down to the purpose of why they are doing whatever they are doing, you get into a hairy situation when you get to court, right? Because really and truly, in order to properly be engaging in an emergency situation, you need an audible signal, right? You need an audible signal to alert the public that there is an emergency and you are proceeding or you are coming from somewhere. The light alone, even at night, the light alone is not necessarily proper emergency procedure. So that is correct. However, if you ever get into a court, they are always going to be in the right, because the judge is going to say, well, it is at the discretion of the constable or the officer them, to decide what is appropriate at the time. You may not hear the siren at that point, but if they deem it necessary, they decide whether or not they are going to turn on the thing. But if they don't have the siren on and they cause an issue, like an accident or, they damage someone's personal property, then that is a different story, right? But if they did not cause any harm or engage in any kind of damage or injury, then obviously it wouldn't even reach a court, right? So it's a hierarchical thing, but we know that sometimes they use these things out of context. We know what it's supposed to be, but them just decide to do whatever them feel like. Many of the time, I'm not gonna say most, many of the times, them cut the line, them turn on them light and run through place where you have traffic and all that something. So what we are gonna do? I mean, if the other part of a larger part of this conversation is we as Jamaicans have nowhere where we can say, all right, everybody come together and we can voice our opinion and say we are against this, we are opposed to this. We don't want this to happen. There is no option for the public to say, then disagree with something. All them do, sometimes they do one little poll on TV, sometimes them claim to them do all kind of little whatever, then walk around and ask people foolishness. And them say, yeah, based on public perception, blah, blah, blah. But there is nowhere for people to really say, we don't agree to this. Right? So if something like that for come about, we would have to institute it. Unfortunately. Vina Fope, you had a question?
My apology for the delay. I didn't really have a question per se, except for the road traffic changes, right? Where there's no need for persons to be printing documentations or walking around with paper, because all of this would have already been in the government's database, which would have been made privy to the police through the Inland Revenue Department. I'm just kind of wondering how persons are dealing with that now. I think some persons may sometimes go ahead and print their documents, but I haven't really heard much with regards to it. But I know what is happening is that police are stopping people and still asking for documentation.
Right.
I was trying to figure out if persons have a good understanding that what has happened is that the government has actually now moved a bit. Whilst they're saving money, they have also moved forward a bit to actually satisfy the requirements of the law, which, according to the judgments from the Supreme Court, is that you don't need to be walking around with a pass, right? So police don't necessarily need to be stopping you and telling you that they're doing VCP checks, which is basically illegal, to check your documentation. They don't need to do that. They have all of that information in the government's database, but I haven't heard anybody been discussing it recently. And this is what I think the government of the day basically rely on, which is the 9-day wonder. They start something, though it is oppressive, persons just make noise for a day or two, and then next week it's all back to normal. They just comply. So I was just kind of wondering if your viewers and my fellow brothers and sisters across Jamaica are having any challenges there, and how are they viewing and or settling in with this change?
Okay. Well, as with anything, it gets pushed aside by the news, right? New news come in, things that are considered last week then just get slowly phased out or fade away. There's always something new every single week to entertain the mind and the eyes, right? Especially now with social media, there is no follow-up on anything. There is no consistency as it relates to the issues that are brought about by, you know, whatever means it shows up in the news. So at the end of the day, we hear a new story about something, no matter how bad it is, within a month or two. Look at last year, we had the drill saga. Then we had the changes to the road traffic act, the amendment, right? Then we had the whole storm thing. Then we had this, we had that. So if some other significant thing don't come up to shed back light on that previous thing, and this is why I said before on this live, on previous lives, we don't have community. What we have is just collective banter via social media, via Facebook, via Instagram, TikTok, and them something there. We don't have any collective database that the people can access and say, yes, this is still an issue. No, that is now fixed, so we can move on from that. We don't have any of that. If we don't try to reach out to a local representative, a member of parliament or whatever, on our own, we don't have no community. We don't have no collective, nothing in the positive. Anytime you have people come together, I went time them face pain. Pain. And that's what I say. Police them still asking for documents. Them asking for license same way. Them asking for everything. So we're just doing a spot check. A spot check is not defined in law as a normal police procedure. That is a special procedure. And even so, you need specifics on the car you are stopping. You can't just random stop every single car or, you know, cherry pick. That is, again, a blatant violation of the Constabulary Force Act, the Road Traffic Act, the Constitution, all of them something that nowhere in law does it state that any law enforcement can prevent crime, which is often what is being pushed in the media by law enforcement. We're trying to prevent crime. We're trying to prevent this from happening. That is impossible. What you end up doing is you end up violating most people's rights in the hope that you will catch one criminal. And that is no longer a free and democratic society. That is closer to martial law. But anybody else who have a view on that regarding the random asking for documents, you can chime in. As well. Donovan, you had a question? All right, Austin, you had a question?
Well, them still ask for license still, cause them claim say license never in the last thing what the changes we make are just registration and insurance and the other thing them, you see me? So when them stop you, them still ask for license.
Right.
You know, I always appreciate when we as brothers can come together and have positive discussions to educate each other, to remind each other, and for us to act in a positive manner, right? And as Mr. 876 pound, 1 pound always say, never argue with the police on the road. We have a JCF. Not all JCF members are bad, and I'm not going to broad brush them. But that doesn't mean we're going to excuse persons for their behavior, right? Because people hide behind people's behavior. But when the police stop you and ask you for your driver's license, right? You can educate me, you can update me, you can guide me. I'm listening. But when a police officer stop you without you having committed an infraction, that is also illegal. If they don't have a reason to stop you, meaning you have hit a car, you are seen committing an offense, they have no reason to ask you for your driver's license. As I would have said earlier when I opened speaking to teacher, there's case laws which indicates that you don't need a pass to go about your lawful business, and the Constitution speaks about your freedom of movement across Jamaica, whether coming in or going out. Right now, the thing is, if you try to speak with an officer on the road, and I'm learning because as somebody was worked in a particular place, and these matters are, rubbing shoulders with certain people, I would have known these things. But trying to educate persons in a way which you're not trying to fight with them, but kind of guide them. Sometimes I ended up in situations that are not favorable to me. And I would agree with 876. Never you fight with the police. And those who know me, they would have known I've been in numerous situations with different police officers right across St. Catherine and Kingston. Even my car was known by the traffic court. It had to be taken to the traffic court, to prove certain things. But the point I'm making is that the police are not here to protect us anymore, and they're like they've gone rogue. Right? We can't depend on them anymore. We can't depend on them. When you're out there, don't be afraid to. I think who was it that was speaking about the use of the emergency lights illegally? If you see an officer doing something that you think is unlawful, let's say they park on a pedestrian crossing, they park on a sidewalk, not because they name police mean that they can do as they feel. One of the first thing I learned when I went into law faculty was this: no one is above the law, right? You cannot break a law to enforce a law.
Right.
All right. So the police cannot break a law going up a one way just because he's trying to catch somebody we alleges is a criminal, or he's alleging is committing an offense. He ought to also follow the law, use the road accordingly as well. So what we have observed is that there's lack of accountability on our part to keep each other updated or knowledgeable. And this is one of the reasons why I appreciate 876 Pound and what he does. Sometimes I can't catch him, but when he does this, he educates a lot of people. Of course, you'll find that some persons in the police force may not like that, because you're empowering the people and they can't get away with abusing people out there. They can't do the hustling, they can't do these. You get what I'm saying? But asking for your documents is actually an unlawful search of your person and your private property. All right? I'll just rest there for now.
Right.
Question, Ryan of Hope. You're in the legal profession, because may have something we would run across here. But anyways, in addition to that now, up to yesterday, me get stopped. Them say under zone of special operation, and them ask me for my license. Yeah, I mean not transpire out it, them just check out and whatever and run plates and whatever you see me, but me just say, it still happen.
Right. I'm no longer in the legal profession, but I do assist persons in the legal profession to get matters addressed in terms of dealing with different departments of government, whether the tax office, the courts, so forth. You have to file documents, and sometimes attorneys going to do them themselves. Sometimes, it takes up a lot of time, right? So I assist them in getting things done. But in relation to whatever operation the police is carrying out, any operation that they're carrying out across the island, it doesn't matter the situation, state of emergency, zone of special operation, a breach is a breach. All right. One of the things I want to encourage myself as well as my fellow brothers to do is to become more accountable to ourselves first. What do I mean by that? I think one of my problem was that when officers breached my rights, I never took it to the extreme as they would have, or ensure or protect myself by ensuring that I Sue them. Let's say, just get to the point. Just sue them. When you sue them, that is on their record. Now they have to become more cautious in how they operate, because when it's on your record, these things affect your ability to be promoted and to grow in rank. Right? You may lose your job if you're found out to be abusing your power and authority, etc. You understand? So for me and all of you here, I want us to start asserting our rights more. Learning how to activate our rights, as 876 would have always encouraged us to come to class. You know, activate our rights and get an attorney. If you have a traffic matter, don't believe that, because it's a simple matter and we can address it and we can talk to the judges, that we should just go and do it ourselves. If you can acquire an attorney, it may be resolved a lot faster than you doing it yourself. And I'm speaking from experience. All right. Firstly, an attorney at law is an officer of the court. And so they are given priority in terms of dealing or addressing matters before the court. So if you don't have a lawyer and you go to court, you'll realize that several attorneys may come and their case get called up or dealt with before yours. It's because they are officers of the court. They are given that privilege. All right. So I would encourage everybody that has a matter in the court, if you can, because lawyers are not cheap. Lawyers are not cheap. And it's having a matter in court is very costly and time consuming, right? Especially if you're doing it yourself. But if you have an attorney who knows what to say or what to say to the judge at the first instance, it's possible that you may not necessarily need to return. But if you go by yourself, you may be going there 3-4 times before the officer even turns up or before you even have a first hearing. You understand? So just have the guidance from me and an encouragement for us to start talking more, start holding each other accountable. If you see the police breaching anything out there, record them. You have the right to record them because they are your servants. When I say servants, I'm not trying to belittle them or be disrespectful to them. They are here working for us. They are public servants. So if them park on the sidewalk, that's a breach. A sidewalk is not meant for any form of vehicle. No bikes, not even the bike riders. It's not meant for them. It's meant for pedestrians to walk. All right. If you park your vehicle on the sidewalk or if you ride on the sidewalk, they can actually penalize you. So let's not encourage them or allow them to feel like they can do whatever they want wantonly. All right. Just a bit for me for a sec.
Yeah, man. Thank you for that, Vina Hope. A couple of things I want to reiterate as it regards to legal matters. By no means am I telling anyone to go do anything. Right? You always have the choice. Some of us want to learn, and some of us would prefer to either pay the ticket or to get an attorney. And that is also okay. Right? You don't have to do anything. This is always an option. Every day you wake up, it's an option to do things. See, Debo asking several questions. I wanted to address the question of a license, right? And driving. It's them are ensure say you have a document to operate the vehicle. You are drive, bro. No, that is your, I guess, opinion. But over here, so we talk strictly in relation to the law. Okay? So according to the legal dictionary, a driver is one employed in conducting or operating a coach, carriage, wagon, or other vehicle, etc., etc. Okay? So you have to be in commerce, you have to be employed, you have to be charging a fee or gaining something. You are for hire. Somebody can hire you, or you are making a profit from the activity of driving. That is now putting you in the definition of a driver. This is why if you go to the Road Traffic Act of 2018, you go to the definition section, there is no definition for a driver. Let us go look it up. Because like I said, we only speak lawful over here. So we have the first instance of driver here is driver's license. Then we have driver's license registrar, driver's offenses registrar, then you have emergency vehicle. there is no definition of a driver. And the reason being is because a driver is a commercial term. It is what is called a regulated activity. So when you say drive, just because the commonplace word, when you get into a car and you start operating the car so it moves, that does not make you a driver. And you are not driving by nature. What you are doing is you are operating the car. Okay? Now, let us look up the term license. Right? Because you ask, why me have a driver's license? And I will answer you in full. But let us get to the legal definition. Right? Because we always have to talk lawful, don't? So let us look up the definition of a license. And marriage license. So, so we reached there already. License. All right. A license means certificate or the document itself which gives permission. Permission for what? License depends on the activity. So in the case of a driver's license, it is a document that gives you permission to drive. And what again is driving? Driving is a commercial activity, something for which you are gaining a profit. Okay? Again, if you use the term drive, driver, driving, you are admitting that you are conducting commerce, so you have to get that out of your head. You are traveling or you are operating a car. Let us also look up the term vehicle. W-X-U-V-W, right? U-V-E-H. Let us look up the term vehicle. V-E-H. So we'll get to the rest of the question then. I have another 15 minutes, so. Vehicle. All right. Here we have vehicle. Let's bring it over. Vehicle. That in or on which a person or thing is or may be carried from one place to another, especially along the ground, also through the air, alley, moving support or container fitted or using for conveyance of bulky objects, a means of conveyance. All right? Any carriage moving on land, either on wheels or runners, a conveyance, that which is used as an instrument of conveyance, transmission or communication. Right? So we only have one definition there. And if we go down to the latter portion where it talks about the Tariff Act, but as defined in the Tariff Act, it has a much broader meaning and includes any sort of conveyance used in the transportation of passengers and merchandise, either by land or by water or through the air. Right? So, transportation of passengers or merchandise. Right? Who carry passengers? Typically a taxi, don't? Right? Transportation of passengers. And merchandise. What's a merchandise? Merchandise is something that is for resale. Right? Something that you use in business. And therefore, a regulated activity. Right? So when people are asking, well, if I am carrying, some cement go my yard, if me I carry some tools, if me I carry some zinc and the police are stop me and tell me, say, me need a green plate, or me need this your permit or that the permit. Is that correct? No, it is not. Absolutely not. The police would then have to prove in court that you were conducting regulated activity. Any license requires terms and conditions, right? Just like if you have a business license. The only way you can charge with a crime or an offense regarding a business license is if you operate contrary, right? If you operate outside of the terms and conditions of that business license. So it is important that you realize that just because you have a driver's license, that does not mean that you are driving. It means that in the case where you are going to conduct an activity that is regulated, you have the license already. But these laws have often been conflated. What does that mean? The regular driver's license, it has restrictions on it, don't? And also, if you get insurance, if you look at your insurance card, it will specifically state that it is only for pleasure. This insurance is granted to the individual only for private activity, not for commerce, not for hire, not for this, not for that. So it gives you the restrictions to let you know that whatever you are doing, the insurance is only for covering private activity. And private activity cannot be regulated. That would mean that basically you're there in your yard and the government can tell you what to do. And that is not the case. The Constitution strictly prohibits that, right? You have the right to privacy. So just because something is considered legal, that does not make it lawful. Unless you are transporting passengers or merchandise, it is not a vehicle, okay? It is a car. Now here is something interesting. I know you can't really see it. Well, some of you may be able to see it. You say, the term was held not to include a street car in the following cases. Interesting, right? So a car is different from a vehicle. While many people will say, well, this is for American courts. This doesn't work in Jamaica. The court is not going to adhere to that or whatever. Really? You want to bet $1 million on that? What if I can show you, which I already have showed you, that the Jamaican courts do support the use of any legal dictionary that support your position? Let us go to the Supreme Court. We'll go through this so many times. No, man, come bet. Put it in the comments. Right? So here in the search box, you can put in Black's Law Dictionary. Right? And on the Supreme Court website itself, you can see cases listed where the courts use the Black's Law Dictionary to make definitions. Here we have Black's Law 8th edition. We have, which one is this? This looks like Black's Law 10th edition, Black's Law 5th edition, Black's Law 5th edition, Black's Law 7th edition. It says Black's Law Dictionary. Let me bring it up closer so I want to see. Let me zoom it in. Zoom in and go over here. So better?
Okay, thank you for that. Because I was wondering if it was Blackstone Dictionary using or indeed a Black's Law. So I don't think I've ever used Black's Law before.
Right. So yes, it is popular in America, but it is recognized anywhere in the world. The reason being, American case law is considered to be a mature case law jurisprudence, right? It is a mature body of law. Their court systems and their cases are very old. They have a long precedence of authority coming forward, right? Now here is something interesting to consider. statutory law is always superior to common law. And let us ensure we know what we're talking about when we say statutory law, right? Statutory law is the written law coming from the legislature, the legislative branch of government that create the laws, right? So let's go to statutory. Sure, USTU. So let's go ST, or I might have to go up to law. Well, let's see if it have it here. Step, statute, foreign law, local statute. All right, let us just look at statute, right? Statute. An act of the legislature declaring, commanding, or prohibiting something, a particular law enacted and established by the will of the legislative department of government. The written will of the legislature solemnly expressed according to the forms necessary to constitute it the law of the state. Okay? This word is used to designate the written law in contradistinction to the unwritten law. So here it is telling you that there are also unwritten laws that can sometimes be used as authority when it concerns a case in the courts. All right? Now let's go up to laws. See if we can distinguish JKL. Last, let's do a law. LAUVW. Law. Let's see if we can find law of flag, lawful. Lawful man. Interesting. Law of the road, law of the staple. Okay, so this one doesn't have it, but you have other legal dictionaries, right? Where you have statutory law and you have common law. Let's bring up common law, right? Common law is another good one. Just so you know exactly what these things mean and you don't walk around with opinions in your head. Common law. All right. Common law. All right. As distinguished from the Roman law, the modern civil law, the canon law, and other systems, the common law is that body of law and juristic theory which was originated, developed, and formulated and is administered in England and has obtained among most of the states and peoples of the Anglo-Saxon stock, as distinguished from law created by the enactment of legislation. The common law comprises the body of those principles and rules of action related to the government and security of persons and property, which derive their authority solely from usages and customs of immemorial antiquity, or from judgments and decrees of the courts, recognizing, affirming, and enforcing such usages and customs, and in this sense, particularly the ancient unwritten law of England. So what does this say? This says that common law is not real law. Common law is based on customs and rules that are enforced as law, that are basically rulings and judgments from the court. That is common law.
In other words, 876. Just as you were reading regarding the statutory law before, it made mentions of unwritten laws, right? So the courts do have the authority to make laws through common laws. In other words, the custom, let's say, for example, something is a practice, all right, and it is deemed reasonable. Judges can use their authority to use that to determine the outcome of a case, which can also become law. I don't know if you understand what I just said.
Yeah, man, I understand.
While statutory law is actually what is made by Parliament, all right? So the legislatures make statutory law, and common law is actually made through cases or decisions made in the courts. That's what basically boils down to be common law.
Right. However, we also have to be careful here with the distinction, because one is superior and one is inferior.
So I agree.
Right? So statutory law that comes from the legislature is superior in application. But I have to put this quote here. Unless you invoke statutory law as the primary law of the case, the court is typically going to use common law. You have a right, to bring in the law of your case into the court. And this is a little bit beyond what I normally say here. You have a right to bring in the authority of your case, right? If there is something defined in statutory law, meaning, for example, you want to use an act of parliament, the court cannot then say, well, the court can. Let me not say that. If you properly invoke statutory law, the court cannot ignore it. The court has to first consider the statutory law, and if there is ambiguity, or if there is something that is of question as it relates to the clarity of the law in relation to your case, the court can then revert to saying, well, we have already ruled in similar cases like this on this matter that X, Y, and Z is the case, right? And they can rule on that. But if you bring up a common law, if you bring up statutory law, and it is clear from the statutory law that your position is justified, the court cannot rally back or to supersede that with common law as their derivation of how they are going to determine the case. That's correct. Statutes override common law, but only where there is no question or no ambiguity as it relates to your case. Okay? So, I have time for one more question. Anyone else have a question? All right, so that is all that we have today. I hope you are entertained, and I hope you learned something that you can possibly use.
Hello.
Wingy, go on.
Oh, question, you hear me?
Yeah.
Yeah, all right, now the court pleading, the consequences of pleading guilty more higher than the consequence of pleading not guilty. Why I say so? You plead guilty, the judge would have asked you to pay a fine, 7 days. You pay the fine and then you go. But when you plead not guilty, you might give another court date in a 3-month time, and then send out a bench warrant for the police, and then when you go to the court, then the police not come, then you get another 3 months, another day for 3 months again, and if the police not come, the court actually throw it out. So me I say all of them time the way you waste, go to court, and the police not come. So me I say most of the time people just go to court and just plead guilty and get over with it. Because if the case if it is a case okay, yeah, go ahead.
Well, all right. If you are go plead guilty, what's the point of going to court? Just pay the ticket and done. You waste time.
Yeah, but I said if I said this, if I plead alright, if I plead not guilty, the court I got give you another court date and send out a bench warrant for the police. And more time the police and come a court, so it can't in the case can't put off till eventually the judge threw it out. So I say all of your time wasted this so.
Right. Yeah, I
So
get
say
that.
yeah.
Oh, is there a way to recover all of the wasted time for you showing up at court?
Yeah. And the police not coming. Because the reason why them write them ticket here, them know say you either go pay it or if you even go court, them not go come and the judge go throw it out.
Well, I can't really answer that question here. But
so if you could have sued them, what the procedure, if you could have get a ticket and them write you a ticket and them not come to court and the judge throw it out. You can sue them, right?
There is a procedure. Either you get an attorney to handle the matter for you, or you learn how to do it. It is not a matter of just answering. You say yes, you can appeal it, or you can go and make a constitutional claim, or just go do this. It is not that simple.
Okay.
But yes, you can. If your case gets thrown out, then you can make additional claims, because that would have been considered. I mean, depending on the situation, I don't know. But in many cases, it's considered malicious prosecution to start. And then, you can build on that with your attorney, or you can learn, how you can possibly get that done. But, yes, anything is possible. It's just you have to have the knowledge to do it or get an attorney.
Okay. Because I just been in a situation that I get ticket to keep on, I go court, plead not guilty, over and over. And a situation like this, if your license expire, or if you renew your license or something like that, you can't go renew it until you clear off your ticket them. Just that explain that. So if you keep on, I go court and put off on the police, them, whereas if you have more than one ticket or so, them keep on and put off. If I get a beer, it go create an impact on you, it go affect you.
Right. So you always have an option. Always have an option. So, like I said before, you can come to class on voiceofjamaica.com and become a signatory. Right? And you can learn to do some of those things, or you can get an attorney. Always have an option. Or you can continue go to court until the judge throw it out. I mean, those are the options that I know of. So either way, you can't stand still. If you stand still, you're going to get convicted, right? So you have to do something. You have to make a decision. Either you just pay the ticket and get it over with, or prepare yourself to show up at the court hearings, or you get an attorney, actually four. Or you get an attorney, and the attorney can properly represent you, or you learn how to do it. Huh?
Can sue them. Sue the police officer would definitely turn up a court.
No, just suing someone, that is not how you do that. I am not advocating that anyone can just go out there and go sue police. That's not how it works. You have to learn what it is that you are doing first, and if you even have a case to sue the police. But without getting a ticket dismissed, you cannot get up boy and go sue police.
No, I mean like it throw out and I get a ticket dismissed. The judge throw out the traffic ticket dismissed. So you can, sue them for some compensation, the time when you waste and the time for you to prepare your case and whatsoever.
No.
If I may interject for a second, 876.
Yeah.
All right. He's going a little bit further, meaning that it should have been a situation where the matter has been disposed of in the traffic court, which is a parish court. Now, I would not encourage anybody to want to do it on their own, to go to this. Whilst we have the knowledge and we can do it, and even myself, it's advice to myself as well. we should not be doing cases in the High Court on our own. I would urge persons to contact an attorney so that they can discuss, the locus standi in regards to their case. When I say locus standi, I mean, valid reasons to bring a case against somebody. Now, if you're going to be suing a police officer, it's not the police themselves alone you're going to be suing. This has to do with the Attorney General, because the Attorney General is the right party to sue when a public servant actually commits an infraction against a citizen. All right, so that is one of the reasons why it's important that we understand what to do, where to go, who to go to. So to get yourself some assistance, the most important thing is to start with an attorney, because there's a whole lot of things and trouble that you might get into. When I say trouble, I'm not trying to scare anyone, but starting a case is one thing. You may file the documents, but then you have different types of hearing sessions that you have to go to. And there's also what I would consider evolution taking place in the judiciary, where persons are now using Zoom platforms and so forth. You may come across some challenges in presenting a case to the judge, getting documents filed on time, etc. So I think it would be better if you have assistance. And in anything that we're doing as brothers, we need to get help. Because sometimes we think that we can handle it on our own, only to run into trouble down the road. And from personal experience, trust me, it's best to start with an attorney. If you can go with an attorney to traffic court the first time you go in, or even the second time, that would be the best thing to do. If you've managed to go without an attorney and you get your matter dismissed, still seek to get an attorney before going to the High Court to file a case, because it's a lot more technical going to the High Court than deal with a matter in the parish court.
Understood.
Okay. Now,
Okay.
So,
let me say something. Now, while I agree partially with Vine of Hope,
No.
right?
Don't agree.
I want to ensure that I make a few things clear. This is not a platform to promote attorney retention. While I said this many times, I am not telling anyone to take on these matters on their own. We all have the options of learning. Now, while I say learning, I am talking about people who are not in an active situation trying to hurry up and get something done. Okay? Learning takes time. So if you are already in a situation, by all means, and again, you have to gauge and weigh the scale on what you think you can handle or what you think you need help with. Some people cannot afford an attorney. So I am not pushing people to say, get a lawyer. It is not always possible. And sometimes it can, it's not guaranteed that you end up in a better position. That should also be considered. Just because you get an attorney, that don't mean you're going to win. Okay? So don't be delusional to think that just because you hire a professional or what is considered a professional to help you with your case, that you are going to win. Even the government loses cases and they have some of the best attorneys in the country. So this platform is for self-help, self-learning, but also you have to balance the scales. If you don't feel that you have the necessary capacity to learn, then by all means, I would say, get help, get assistance. This is not for everybody. So I am not here advocating to say, yeah, you can go in there by yourself and you can do this, you can do that. But at the same time, you can. If you learn all the steps and the proper procedures, it is there in the body of law, it is not something hidden. All the rules and the regulations and all of the technicalities that are required to start your case, to properly defend the case, to properly prosecute a case, all of those things, the same thing the attorneys are using, are available online. They are available in the bodies of law. So it is not some secret sauce they are cooking up. While you can speculate on what happened behind closed doors, everything that they are using is within the gamut of the law, right? So you can also learn that for yourself as well. So yes, the attorney option is there, but this is not the platform to promote, go and get an attorney, go and get an attorney. This is why I teach the basics of the law. And if you want to learn more, you can join Voice of Jamaica. Okay? So I just want to make that clear. I just want to ensure that you have proper information. If you are going to argue a specific point or a specific matter, it is up to you to gain the knowledge necessary so that you can properly deliberate your case or your matter or your subject or whatever it is that you're doing in or out of court. Right? Again, arguing does not help. It does not. So do not argue with the police on the side of the road. See? So, I do have to run though. Thank you all for joining. I hope you learned something today. I hope you got a wealth of information. And please ensure that you protect yourself and continue learning and do not take on more than you can chew. All right? So big up on yourself. Thank you, guests, for joining the panel as well. And I will catch you next time. I can't tell you when I'm going to be live again because when I plan for the lives, the agent then come out and them start report the live. So you don't know already. It have to be spontaneous. So big up on yourself. Lawful. Always.